Well, good morning, everybody. Welcome to our semi-annual Trustees Workshop. I hope you're staying warm on this blistery day where we are all here in Los Angeles County being subject to Santa Ana winds, the devil winds as they call them. Those are always a little scary, but stay bundled up and tied down, and I know we'll get through this. So today's topic is we are doing our famous or semi-famous Trustees Workshop, Steps to Take and Mistakes to Avoid. Trust administration as well as probate administration is a pretty complicated topic. It's difficult to cover in an hour and a half. And in fact, it's one of the topics that I continually get educated on. I probably sat through about 3 hours of education on this topic in the last 2 months. But I'm thrilled to be able to share a little bit of my knowledge and experience and background with this. And we're glad that you're here. If you're an existing client, part of what we want to try to do is bring you up to speed to give you an idea of how these things work. And if you're a new or prospective client, welcome. We're thrilled to have you. I think this will give you a sort of a nice feel as to how we practice and how we work and how we love supporting and helping our clients through some of the challenging inflection points during their lives. So without further ado, let's get into it. So if you had a chance, we emailed you, if you registered ahead of time, a trustee shop workbook that follows a lot of the material today. There's also a place for you to take notes in it. We have found it to be kind of helpful, so feel free to use that. There was also an opportunity to download it. Now, if for some reason you didn't get the workbook, don't worry. Send us an email either through info@schomerlaw.com or caesar@schomerlaw.com. We'd be happy to email you a copy of this. So as you go through the materials, or as you listen to my presentation today and go through the materials, if you have any questions that come up, jot them down, take notes. A lot of the stuff that we have in here are helpful checklists, things to help you start family conversations. They include checklists on steps to take during death or incapacity, your own planning, and a trust review checklist. When we get near the end, if I have some extra time, we'll try to entertain a few questions, which you can submit by posting on the question or the chat box. There's a Q&A box, so you can do that. And if not, we are also available for consultation. So if there's something that's burning for you, that's a big concern, feel free to do that as well. So first order of business, you may not have gotten a pat on the back lately, but I want to say congratulations to you. You are taking steps to become more knowledgeable about estate planning, to know what to do and when to do it, to understand legal steps to take as elders age and their health fails, and to ensure that your asset distributions are conflict-free. I've said this at a number of seminars, but one of the things that really sort of makes me sad is when I get a new family in our office and I ask them, who prepared your estate plan, or what do you know about it? And they give me sort of a blank stare and they look and they say, well, we did this thing and here it is, but I don't know what it says or how it works or what to do. So we are really big believers in client empowerment. We also, besides wanting you to know how this stuff works and feel in charge of your plan, we also want you to know that if you're a client of ours, we're here for you. So if the questions become too complicated, you can always call us up and we can fill you in on the specifics of your plan or help you navigate some of the intricacies. Probably the most common source of calls we get from existing clients include things like they're out buying new assets, which is a wonderful thing. Hey, Scott, we're buying this house. What do I need to do? How do I take title? We provide instructions to you in our plans, but these are the kind of calls that we welcome. We always love hearing from our clients, and we love making sure that the plan that we created for you worked correctly. So as a continuum of all this, this is an ongoing conversation where we're covering a lot of these topics and reviewing them for you. So we hope that you find all this material helpful. So again, the reasons for this is to give you a deeper understanding of your estate plan and how to use it to help you prepare for the future and avoid being unprepared, so that everyone knows their roles and responsibilities, and give you some tips to try to avoid some common and costly mistakes. Here at the Schomer Law Group, one of the things that we really pride ourselves on is there are a number of people that practice in the area of trust and estates, or services that do this type of work, that don't really understand fully how these documents work. So we not only write these plans, administer these plans, but we've also watched numerous plans go through the court system and be fought over, fights over interpretation of clauses and what language means and whether it's still applicable, all this stuff. So it's one thing to understand the basics of how to put the plan together, but to really understand how it works through all the stages of life and how it really saves you heartache and hassle is really sort of a key skill that we bring to our clients, and a key expertise. We're very proud of it. And that's part of what we're trying to do today, is to try to educate you in all of our little tips and tricks, so to say. So one of the things that we have learned over the years is that one of the big key mistakes, for lack of a better description, is lack of communication. Sometimes our seniors, or even our not so seniors, don't share information. And they don't know, the kids or the loved ones who are named in the plan don't have any idea that they're named in the plan. And in fact, I get a lot of calls from people who are not yet my clients, where they call up and I ask them, well, do your parents have an estate plan? Maybe you lost your mom or you lost your dad. And I'll say, what did they have, and what are their assets, and do they have a trust or will? And the child will, or the loved one will look at me with a blank stare and say, I don't know. They never told me anything. I don't have any idea where things are, how they organized it, whether I'm in charge. And also, sometimes this leads to secrecy among siblings or other family members. And that type of stuff often results in both communication breakdowns, but lawsuits. So the fights actually get dragged into court, and people sue each other for failing to turn over copies of the plan, or telling you what your share is, or who's in charge, and all these types of things, or not even knowing that you're the trustee. So family doesn't know that they're responsible to be the successor trustee. So when you hit those situations, when you have somebody that's not planned or not communicated with the loved ones, then what ends up happening is the person that has to take over ends up having to do detective work. You have to go through and start looking at the mail, digging around in their personal effects, start asking a lot of questions, sending out emails. Hey, do you know anything about my parents? Do you know anything about their plan? And so you can imagine all the sort of the stress and the turmoil that this creates as well. So really, lack of communication is really one of the biggest things that we encounter. And it's one of the reasons why we encourage our clients to have a dialogue and work with their loved ones and family members. So why do estate plans fail? Well, often they fail because the family didn't know that the documents existed. They didn't know a trust existed, how or when to use the documents, what the responsibilities were, who to go to for help. When they acted, they often acted too late. They acted improperly, and sometimes transferring assets prematurely and cause unnecessary tax burden. So people don't even realize the taxation mistakes that they're making, or the deep holes that they put themselves in. So often it's really good and important to sit down and talk to somebody that knows what's going on before you just sort of jump in and try to do it yourself. So the negative impact of this, of course, is financial losses, unnecessary taxes and costs, devastating nursing home expenses, the wrong people inheriting, litigation, family disputes and disappointments, and delay. One of the things that people often don't think about is when you defund a trust or pull assets out of a trust, you are potentially exposing them to probate court administration, which we're going to talk a little bit more about in detail. But once assets have to go through probate court, they are potentially subject to Medi-Cal recovery out here in California, Medicaid recovery in the rest of the country. And what that means is that potentially some portion of the estate could go back to pay back the government when all that could have been avoided by simply making sure that the plan was working and working correctly. So today's topics, the things that we're going to talk about other than the general things I've talked about in the introduction here are, we're going to start with estate planning basics, wills and trusts. What are they? What are the differences? How do they work? Which one's superior? We're going to talk about the different roles. So you'll hear a lot of people throw around terms: executor, trustee, power of attorney, agent, healthcare agent. What do all these things mean? Guardian, executor, conservator. Who am I? What do I do? What do these things mean? Next, we're going to talk about what happens when somebody becomes incapacitated. Then we'll talk about what happens when somebody passes away. So in both instances, those are events of administration. Those are circumstances under which a trustee may have to dig in and do the work and do trust administration, which is really sort of the big theme of today, trustee school. We're going to give you some examples of mistakes to avoid. We're going to have a little quiz, so be prepared. I'm going to hit you with a couple of questions and we'll see how you do. And then we will, at the end, save some time for questions and answers. So real briefly, if you don't know me or forgotten who I am, I'm Scott Schomer. I'm the founder and the owner of the Schomer Law Group. That's me there. I'm a graduate of Boston University School of Law, been recognized as a certified specialist by the State Bar of a Board of Specialization of the State Bar of California. I am also a financial planner with Abundance Financial, and I receive regular awards and accolades for the work that we do. Now, the firm is not just me. We believe very strongly here in a team approach. And so I have been very blessed to have been able to assemble some amazing colleagues to work with us. You worked with a number of them. So first up are our associate attorneys, Melissa Padilla, Nathan Coppernall, and Anita Shaw. Also here is my chief financial officer, also known as my significantly better half, Colleen Schomer. She's our CFO. And then we have an amazing team of paraprofessionals, paralegals, including Caesar Gill, who both is a paralegal, but our marketing and operations director, Nancy Berg, who's our probate and estates paralegal, as is Daniela Prebick, and Gina Bentley is our one of our newest additions to the team. So welcome one and all. They're an amazing crew, and it's one of the reasons why I think we have one of the best organizations in the South Bay, if not all of Los Angeles. So as we go through the material today, realize that your current status doesn't really matter that much to this material. The concepts that we're going to cover today apply whether you're married, single, divorced, widowed, or an unmarried couple. Now, a lot of these different techniques have to be tweaked a little bit, but the concepts in general are going to apply no matter what station of life that you may find yourself in. Okay, so first up, let's cover some estate planning basics. You may know a lot of these things, but it's not a bad idea to review them. So realize that when we are engaging in planning, we are doing estate planning for your entire life. So we are planning during incapacity and also planning for your eventual demise. So if incapacity is a little too technical, what we mean by that is you're not able to manage your affairs. So you've perhaps had a stroke, perhaps you've been in a car accident and you're in a coma or a debilitated state. Maybe you've had developed Alzheimer's or dementia, something else, but for whatever reason, you're not able to function anymore. And we're planning for that possibility, as well as the possibility or the eventuality that you're going to pass away and no longer be with us. Now, realize with this, one of the ways that we like to think about our role here, and I think the reason for this will be evidenced, is we are really specialists in what I refer to as probate avoidance. So I know you've heard the term probate before. It's kind of a bad word, although I do love probate court. I go there on a regular basis. But our goal for most of our clients, especially the ones we're planning with, is we want to keep you out of probate court for the reasons that we're going to talk about. Now, when I say we want to keep you out of probate court, really what I'm talking about is we want to keep your estate and your affairs out of probate court. So that brings us to our next definition, and that is, what is an estate? So an estate is, for lack of better description, everything you own or control. Sometimes when I'm meeting with clients, I'll say your stuff, right? All your possessions, all your worldly wealth, all the things you've worked so hard all your life to accumulate and develop. That includes houses, cash and stocks, mutual funds, automobiles, retirement accounts, life insurance, all of these things. And our goal when we're engaging in probate avoidance or estate planning is to avoid government involvement. Why do you want to have the government involved in this stuff? To avoid taxes and extra fees, to eliminate or reduce nursing home costs, to protect your family from creditors and predators, to eliminate family fights over money, and try to pass along life lessons, including your wisdom and your values. Now, when you come to our world and you're talking about estate planning, there are basically two types of commonly known estate plans that lawyers and law firms get involved in. One is referred to as what we call a will-only plan. So a will-only plan is all you do is sit down and write some type of will. In California, they recognize something called a holographic will, which is a handwritten will. In order for it to work, it has to be completely in your handwriting. You have to declare that it's your last will and testament. You have to date it. You have to sign it. But that is a type of a plan. The alternative to a will-based plan is a trust. And because of the way these two plans are administered, I like to describe the difference between a will and a trust-based plan. In other words, which one is better, as the difference between the private system and the public system. The public system is the will-based plan. So as we'll talk about, when you write a will and you have assets, most likely your assets are going to go through probate court. So that's not a probate avoidance device. When you have a trust, that's part of the private system. It stays private, it stays out of the court system. So let's go over quickly the basics. With a will only, a will is an expression of how you want to leave your stuff after you pass away. I call it instructions to the probate judge about how you want your assets distributed. A will allows for the nomination of guardians for your minor children if you have them. A will does not provide any protection for incapacity or disability. So if all you do is a will and you end up having a stroke or become disabled somehow, then you haven't planned. A will is not going to help you, because remember, it's only instructions after you're dead, right? A will ensures both a living probate and a death probate. So that basically a will is a one-way ticket, assuming all you have is a will. A will is a one-way ticket to the probate court. That really is what it is. And one of the things that gets missed a lot is that it subjects your estate and your assets to Medi-Cal recovery. So these are your recovery for nursing home costs and expenses. So Medi-Cal only seeks reimbursements if there is open probate. If all of your assets avoid probate and are passed privately, you'll never hear from the Department of Health Services or Medi-Cal again, right? Okay, so the alternative to that is a trust. Trust manages assets in your estate while you're alive. It provides protection in the case of disability and incapacity, avoiding the living probate, also known as a conservatorship here in California. It provides an easier method of transfer of wealth and inheritance to loved ones. Also gives you significantly better levels of control, especially if you have situations with an errant child or a disabled child, somebody with special needs. You can do amazing things with trusts, and it avoids probate court and the involvement of judges. Again, not that I don't love judges, but accessing the probate system costs time and money. Just a real quick aside, I appeared called ready for a trial down in Orange County yesterday, and the judge basically moved our trial back to February, but said we might be hanging around for months before we get an open courtroom. each of the courts, the judges down in Orange County apparently have over 900 pending matters, and they're not sure when they can get to our trial. It's kind of remarkable, but the public court system is just really overburdened with a lot of people that didn't sit down and do the right thing and do planning ahead of time. So just an interesting perspective. Okay, as I said before, a will only speaks at death. It establishes who gets your stuff and how it goes. It requires public probate court to administer, and it does not provide disability protection while you're alive. So how does a will work if you're going to have to go through probate for death? Well, this is basically the way it flows is when both spouses are alive, the will sits in a drawer and does nothing, right? Because you're waiting for it to speak when you pass away. The first spouse has incapacity. Let's say they have an accident or they have a stroke or become demented. Then you have to file what's known as the living probate or the conservatorship, which is a lawsuit. It gets filed in probate court. The first spouse then dies. If there are probate assets that are in the name of the first spouse alone and have no other way to pass, then you have to do a second lawsuit, which is the death probate, which is commonly known as probate administration. You then find yourself repeating the process with the second spouse. And again, if we suffer an event of incapacity, we're back in the conservatorship court. And then at the second death, we're back to another living probate. So with a situation like this, if you have no plan in place, or all you do is sit down and write a couple of wills. I know a number of people who like to think of themselves as do-it-yourselfers. I'm a little bit of that like myself. But if you sit down and try to do that yourself, you potentially are exposing you and your family to 4 separate lawsuits. That's what probate is. Each of these proceedings is a separate lawsuit. And as part of the separate lawsuit process, it comes with all these costs, expenses, and we're going to detail that a little bit more later. Now, when you file one of these things, when you file something in probate court, either as a living probate or a death probate, a probate administration, there are a number of roles that are often documented or named in the will. The first is the testator or testrix. So that's you if you're writing the will. That's the person that's sitting down and saying, I'm Scott, and here's where I want my stuff to go. The next person that you designate or nominate, and we see this mistake a lot in people that try to do it themselves, is they forget to designate somebody, but as the executor or the personal representative, also sometimes called the administrator. So that's the person that's going to run the probate. So I, Scott, hereby nominate my wife, Colleen, to be my executor. And if she can't do it, I nominate my brother to be the executor. So that's what an executor is. They are the person that actually is going to do the business of administering the will. Now, a guardian is a person that would be appointed by the court to take care of your minor children. And then the last term that you need to know when you're doing probate administration is the beneficiary. Beneficiary is the person that receives the assets of the estate. So if I, Scott, appoint my wife, Colleen, to be executor of my will, and I leave all of my estate to my wife, then she is both the executor and the beneficiary. If I put my oldest child in charge of the estate, so I say my oldest daughter is the executor, and then I might say, well, since my wife has predeceased me, I'm going to split my estate between my two daughters, then they would be the beneficiaries. So those are our key roles when we're talking about probate or probate administration. Often the executor position gets mixed up with our next piece of administration, which is trust administration. So the person that fills the executor role in a trust is a trustee. We'll talk about that a little bit more. So what's the difference? Why does this thing avoid probate? Again, as I indicated, it's a private contract. It's a private agreement. We like to think of it as a box or a treasure chest. So when you create a trust, what you do is you put your assets inside of the trust. And what that does is it gives you the ability to pass the trust or pass the treasure chest to the people you love without getting a judge involved, without filing a lawsuit. It can be done all privately. But one of the most important things to know with trust administration is that a trustee or a trust cannot manage or administer assets that are not inside the box. You got to get the assets inside the box. We'll talk about that some more later. That is really the secret sauce. So in fact, one of the reasons that you get somebody appointed to be an executor, one of the reasons you open a probate is that a deceased person has an asset in their name. Think of a house. So Scott owns a house, maybe he owns it by himself. He dies. How can Scott sign a deed and transfer the house after he's dead? That's the point of opening a probate and putting somebody in charge. With a trust, what we're going to do is we're going to put that asset, we're going to put that house into the box ahead of time. This is called funding the trust. You're going to hear me use that word repeatedly during the seminar today. Trust funding. It's one of the most important things that is done with good estate planning. It's one of the things that is most often overlooked. And it's one of the reasons that we invite clients back every 3 years to sit and have a review with them is let's review your funding. Let's review to make sure your assets are properly in the trust. That's what we mean. So this is how a trust works. This is the secret sauce that allows the trust to avoid the court system. Okay. So before we showed you how a trust, or I'm sorry, how a will was administered during the various stages of life and death. We showed you how there were 4 lawsuits. So let's compare how a trust is administered using also a power of attorney. That's also a document we create with a trust when you have these various stages. So first up, both spouses are alive and have capacity. So the trust is prepared and there it sits proudly on your shelf or in your important records. And then we have an incapacity. So in this situation, when you didn't have a plan for incapacity, you would have to go to probate court. Not anymore. All the assets can be managed privately. You don't have to go see a judge. The next step, you have a death. What happens? Well, you administer the trust. You go through the process of trust administration, which we're going through today, and we're going to go through more details. But the assets generally get passed to the people who are named in the trust. Oftentimes, it's just the surviving spouse. So the surviving spouse passes all the assets to himself or herself. Next step is the second spouse has incapacity. Again, question is whether we need to go to court. And of course, the answer is no. And then our second spouse passes away. And we have to go through another step of trust administration, which would be passing the assets out to your children. But what you'll notice most prominently missing from this flow is that there's no mention of a probate, there's no visit to the probate court, and there is no need to handle a probate or file any of these lawsuits. They protect you from court system. It's a wonderful, wonderful device. So it provides you protection during your lifetime. It allows you the flexibility to amend it, revoke it, update it, change it. It allows the management of finances. So one of the things you can do, for instance, is you could make a decision. Maybe you want to go travel around the world for a year, and you can make the decision to appoint somebody you trust to be in charge of your trust and manage all your assets in your absence. So you can even do things like that. Upon incapacity or illness, it allows for the planning of long-term care without going broke. You set up end-of-life decision-making treatments. You don't have to worry about a Terry Schiavo situation. Allows the management of medical treatment options, finances, and it avoids the court or conservatorship. And then finally, upon death, it manages how finances are dealt with and how assets are distributed. And it can even protect inheritances for beneficiaries. We have these types of discussions all the time, especially with clients that have, for instance, special needs children, or even young children or children that are not quite there to be able to take care of things themselves. So that's how a trust works with powers of attorney. Now, whenever you create a trust, I know I've been spending all this time this morning telling you about how horrible wills can be. But one of the things that you need to know, and this is the subtlety of some of the things that we do, is whenever you prepare a trust, you have to also prepare a will. Now that seems like kind of a contradiction, doesn't it? Why would you have a will if you have a trust? Aren't they different? Well, no, when you create a trust, you create a particular type of will. It is referred to as a pour over will. And you can see the pouring into. So the basic rule here with a pour over will is that you have very little substance in it. So you don't tell the world who your beneficiaries are other than your trust. You don't go into great detail about how to manage things or what goes on. You simply appoint somebody and you say, I want all of my assets to go into the trust. And the reason for this is it makes sure if you didn't do the funding, the pour over will make sure that the assets are going to be funded in the trust so that your testamentary decisions only have to be made once. In other words, who do you want to receive your estate? Who do you want to receive your stuff? All gets made through the trust instrument itself. The will is really there as a backup or kind of an insurance policy. It's not insurance, but it's a document there to make sure the trust works correctly. So this is another one that I hear clients say all the time, or people I meet with, they'll say, oh, I don't have a will, I just have a trust. That's all I have. Well, if your trust has been done by anybody mildly competent, you also have a will. You have a pour over will. Okay. So I've talked about trusts. I've talked about them being like a treasure chest. Is there another way that I can describe them to you so you have a basic understanding of them? And yes, there is. The other way that I like to talk about trusts, because it then highlights the role, is that a trust is at its core nothing other than, for your purposes, a contract, right? It's a contract that you essentially sign with yourself. Now, the difference between a trust and most contracts you sign is what you're usually used to is what we call a two-party contract. So a two-party contract might be a purchase and sale agreement, buyer, seller, two parties, right? Or a lease, landlord, tenant, two parties. So a trust is a contract that has three parties to it. So the three parties to a trust, these are the roles of a trust, are first up the trustors. Those are the people that create or sign the trust. So, so I signed the Schomer Family Trust. I am the trustor of it. The second role or roles are the trustees. Those are the people that manage the assets, right? They make the decision. Do we buy the house? Do we sell the house? Do we invest our assets in this portfolio? Do we trade this stock? Do we take out this money? They make the financial decisions about management of the trust, okay? The third position is the beneficiary, who gets the benefit of all the treasure that's in the treasure box, right? Or in the treasure chest. Now, we have three different couples in this diagram here to show you the three different roles. But the reality is, if you create a trust, most likely you are sitting in all three positions, right? You're the trustor, you created it. You're the trustee, it's your treasure. You get to decide what to do with it. Do you sell, buy, refinance? And during your lifetime, you are also the beneficiary. You get to use your assets, right? There it is. That is the essence of what a trust agreement is. But then that gets us to why a trust agreement works. And to focus on that, what I'm going to do is turn you to the next role. And that is the role of the difference between the role of the trustee versus the successor trustee. This is another area that people often get a little confused about. But a trustee is somebody who's usually the first appointment. So it's the person that helps create the trust, although it doesn't necessarily have to be. But a trustee is the person that manages the assets, has a fiduciary relationship, has to work with the highest integrity and fidelity. And that's essentially what a fiduciary relationship is. And I'm going to talk more about what a fiduciary is in a minute. A successor trustee is somebody that is the backup. somebody that steps in and takes over when the original trustee can't do the job anymore. So a very common scenario, and I sort of highlighted this already, is that a set of parents will set up a trust, and then they'll say, well, if I can't do this anymore, then I want my son to take over as successor trustee. I want my daughter to take over as successor trustee. So remember, if we go back to our last slide, taking over as trustee doesn't mean that your daughter gets all the stuff. If you're alive, you're still the beneficiary of everything that's in your trust. So the role of a successor trustee in that stage would be to take over and make sure that you're cared for, make sure that the assets, that the treasure inside the box is used for your benefit, right? But then again, just like there is a successor trustee, there are successor or contingent beneficiaries. So once a beneficiary passes away, maybe you as the settlor pass away, then you say to us, we put this in an agreement, once I pass away, I want my estate to go to my wife. Or once I pass away, I want my estate to go in equal shares to my kids. Or once I pass away, I want my estate to go 1/3 to my church, or 1/3 to my synagogue, or 1/3 to my my favorite charity. You get the basic idea. So it's a contract, it's a flexible device while you're alive, and it allows for backups and plan Bs, as we like to say, contingent arrangements. Okay. So since I've used the word fiduciary, let's talk a little bit about this. What is a fiduciary and what is fiduciary duty? So this is really the heart of what a trust and trust administration and a trustee duty is. But let me make sure that you understand how these work. So all of these positions are fiduciary positions. A trustee is a person who's in charge of a trust. An executor is a person who's in charge of a will, whether it's a pour over or a regular will. An administrator is also a person, depending on the appointment of the court, that's in charge of a will. An agent is somebody that is designated to act in a power of attorney document. So a lot of times people will come to me and they'll say, oh, he's the power of attorney. Well, not quite. What he really is, or she is the agent under a power of attorney, or the attorney in fact under a power of attorney. By the way, attorney in fact is not to be confused with attorney at law. Those are different things. An attorney in fact is an agent. So they are the people that are given fiduciary duties that are empowered to act under the power of attorney, which usually takes effect when you're incapacitated. For healthcare documents, for making decisions about your medical care, the healthcare agent, also sometimes called the healthcare attorney, in fact, or the healthcare agent, is also a fiduciary position. They are used and charged with using their best judgment to care for you if you nominate them in the document. Finally, the last position is the conservator. That's if you've had no plan in place and the court has to appoint somebody. If the court appoints somebody, that person is not an healthcare agent or not an attorney. In fact, they are appointed as a conservator. And there's a whole set of rules relating to them. But the most important thing you need to know is that they are a fiduciary. So what comes with the term fiduciary? What requirements and what roles? So the core of it is something called a fiduciary duty. A fiduciary must protect assets under his or her control. They must prudently invest the assets unless they are specifically excused. What do I mean by that? The most common example that you probably see is the general propositions that a trustee has to make assets productive. In other words, have them generating income or have them generating investment returns. But often one of the biggest assets in a trust is the personal residence. And the incapacitated person often wants to live in their residence and keep it. So we often in most trust documents carve that out and say, you don't have to make the house productive, but we expect everything else to be productive, right? Because the person wants to live in their house. All right. When you're a fiduciary, you have to account for your use of funds. One of the big bozo no-nos, if you ever watched Bozo growing up, is as a trustee, you have to be very careful. You don't engage in cash transactions. Everything has to have a trail and a receipt or a canceled check or a payment. You have to disclose your actions. You can't do this secretly or privately. You have to act prudently and responsibly. So on a regular basis, I get into conversations with clients where they come and say, hey, I've got this great idea. I'm going to take the trust assets and go buy some swampland in Florida. I hear it's going to do 101 return. You can do those types of things with your money if that's what you want, but you're gambling with somebody else's money. You're gambling with the settler or the trustor's money. So you have to be prudent and you have to be responsible. You have to be more careful than you might be with your own personal funds. Depends on what kind of investing you do and what you think. You have to act in such a way that it benefits the beneficiaries and not you personally. So that means you have to be very careful about insider transactions or buying things from the estate. And you always have to be objective and fair with the beneficiaries. So you can't go in and change. If the trust says divided amongst the 3 kids, you can't go in and say, well, as your uncle, I always liked the middle child the best, and I'm going to give them more money, or I'm going to give them the money first before I give it to anybody else. That's not being objective and fair and treating everybody equally. So you have to really be an adult in the situation when you are functioning as a trustee. It's the highest duty that's recognized under California law. So some do nots, fiduciaries may not exert any undue influence, be selfish or take advantage. They must be very careful about self-dealing. So what that means is stepping up and saying, oh, I'm gonna get a bargain. I'm gonna buy a property from the trust at a discount because I'm in charge. Remember, when you're doing something like that, you're functioning as both the seller because the trust is selling, and then you're acting in your own regard. So you have to be very careful with those types of relationships. You have to be careful at doing it in such a way that benefits the fiduciary or prejudices the person to whom the duty is owed. So in one of my earlier trustee schools, one of the things that I compared this to is the Boy Scout pledge or oath. I think the Girl Scout pledge is very similar. If you ever a scout growing up, how did the saying go? I, as a scout, pledged to be thrifty, clean, reverent, wise. I can't even remember it anymore. But this is essentially what you're doing when you sign up to be a trustee. You're signing up to take care of somebody and to take care of an estate, depending on what the circumstances are, and put their interests in front of yours. Okay, that's the key. If you can remember these key principles, if you ever get into a fiduciary role, these are going to serve you better than anything else. These are going to protect you. By the way, in most circumstances, if you are functioning in this role, most good documents will authorize you as the fiduciary to go get professional help. Now, that doesn't generally mean a therapist. You don't have to go get therapy to be a trustee. But what it does do is if you do your taxes yourself, for instance, you may want to hire somebody like a CPA or an enrolled agent to do the taxes for the trust, because you don't want to make mistakes. You want to have a professional that does it. Same thing with legal advice or real estate professionals. You don't want to do for sale by owner as a trustee. You want to have professionals involved because that protects you and it ensures that you're acting in the best interests of the beneficiaries, right? That you're doing everything you can to protect them. That's the core of fiduciary duty. If you understand that from the seminar, that and trust funding, those are probably the most 2 important concepts that you can learn today. Burn those in your brain, as we like to say. All right. So let's talk about what happens when somebody becomes incapacitated, because this is our first stage of some level of administration, either trust administration or administration through a conservatorship. So what is an incapacity during life? It can be the sort of the common known ones such as dementia, Alzheimer's disease, Parkinson's disease, stroke, but it can also be a physical incapacity. We've helped families where people have gotten into auto accidents or been struck by cars and found themselves in comas or in hospitalization for extended times. We've had people that have fallen off ladders and been incapable to do all these things. So what are the essential documents? Well, from our perspective, a couple of the key ones in addition to a trust include an advanced healthcare directive, which is a document where you as an individual appoint somebody to be the decision maker for your health decisions. So if you're laying there in a coma and they have to decide whether they want to operate or not, who makes that decision? Who speaks for you in an advanced healthcare directive? That's the person that you appoint as the person that acts. Concurrently with that, we always create, and we think an important document is a HIPAA release. If you've not heard of HIPAA before, it's the privacy law. And with a document like this, what we're doing is we're saying anybody that you appoint to be your healthcare agent should have full access to your medical records so that they have all the information they need to make a proper medical decision. Oh, so-and-so is diabetic. Gee, if I had known that, I wouldn't have authorized the surgery, because, you get the idea. They need to know what your history is and what your conditions are. A related document is the property power of attorney. This authorizes somebody, a trusted person, to manage assets and finances. This is very similar to a trustee role, but it deals with assets that are, or situations that are outside of the trust. So what would be outside of our treasure chest? What would be outside of our box? Well, probably the most common one would be retirement accounts, 401ks, 403bs. So we can't put those in a trust without triggering tax consequences. So a power of attorney would allow the trusted person to be able to go in, change your investments, draw down on the account if you needed to pay bills. But more importantly, a power of attorney would allow your designated agent to be able to do things like sign contracts for care for you, hire caregivers, pay for these people, help get you admitted into some type of rehabilitation facility. So the financial power of attorney allows them to step in and basically do the things that you would want to do for actions that are not inside of the trust, that are not trust funded assets. So we again then come back to our distinction between the public versus the private administration. So if all you have is a will, or all you have is nothing, then what you're looking at is when you become incapacitated, having to petition the court, or having somebody petition the court on your behalf and apply, as opposed to a living trust where you've designated these people, where you've appointed people to be your healthcare proxies, where you've given authority to be able to access the records. So what's the big difference? What are we sort of most concerned about? Well, for me, it's sort of what I refer to as the spinning of the wheel, right? Wheel of fortune, maybe. So the problem is, if this is all in the public court and you've not made clear what your wishes are, then any of these potential people can step up as an interested party and apply for your benefit. So look around. If you've not done these things, if you've not done a good estate plan, look around and think to yourself, who might want to come in and take over your life, right? Might it be a strange relative, or might your 2 kids fight over who's going to be in charge, or your 3 kids going to fight over, or what about an ex-spouse? Are they going to ride in and say, I need to be in charge of his estate because I'm worried he's not going to keep paying child support, or he's not going to keep paying alimony or something like that. It's a big world. And if you need sort of a popular illustration of this, if you follow the Britney Spears conservatorship, you probably remember that her father wrote in and appointed and got put in charge of Britney's life for a long time, and Britney didn't like it. And what has surfaced recently was she went in and fought to get her father out. And you don't even want to know how many millions of dollars in legal fees were spent on that one. And while you may not have the net worth of Britney Spears, I can tell you that I see families on a regular basis where we get into fights like this, where the kids don't trust each other, or there's, a new spouse or a different family member or an uncle who thinks they know better. And suddenly there you are in front of the judge, and everybody's fighting and jockeying to see who gets to be in control. Adds up to thousands and thousands of dollars, if not hundreds of thousands, creates horrible pain and conflict, all of which could have been avoided if you had sat down and done this privately and dealt with it. So, you know, even when there aren't battles or fights like that, of course, a conservatorship is humiliating because you're essentially suing your loved one, or somebody's suing you if you're the incapacitated person. They're alleging that you're incompetent, right? That's what Brittany was accused of. They said that she's not competent to manage her own affairs. Not a fun thing to read about in the paper, not a fun thing to see published in the court record. The court's in charge, so they make the decision. It's time consuming. Your personal information is disclosed, and it's expensive, expensive, expensive. So when somebody comes to us and says, hey, you know, I have a very basic one, just dad did nothing and I need to put him under conservatorship, the average fees and costs to get one of these started is at least about $10,000 a year. And that's assuming there aren't any fights. The filing fee for one of these is over $1,000. If you get in and there's a fight, you can take that $10,000 number and multiply it by 2, by 5, by 10, or more. And I've seen all of these cases, and it is a hot mess. It's definitely a process that you want to avoid. So what are the key roles in a conservatorship? Well, the key roles are the judge, of course. The judge at the end of the day makes all the decisions, and they got their own beliefs, wishes, and desires. The incapacitated individual would be the conservatee. I keep picking on poor Brittany. We love Brittany, but that's what her role was. She was the conservatee. She was the person under the conservatorship. Conservator or the guardian is the person who's in charge. Again, in Brittany's case, that was her father for at least some time. And then the conservatorship attorney, and actually there are almost always multiple attorneys, because a court will appoint one attorney to represent the conservatee, and the conservator has to have his or her own conservator attorney. And if there are other people that are weighing in and have opinions about how care should be done, then they all generally have their own attorneys, and you can see how this escalates and just goes nuts and gets very expensive. Now, let's contrast that again with private administration, with incapacity. You've essentially got one, maybe two people. Often with I would say the majority of my clients' plans, they often have a favored person, like a spouse first, and then a son or a daughter first, who often fills all of these incapacity roles, primarily the successor trustee, but also sometimes the healthcare agent and the financial power of attorney. So their role is to follow the instructions of the trusts. So the first thing you notice is that there's no mention of a judge, because there is no lawsuit or pleading. There's also not mention of 3 or 4 lawyers, because you often don't need 3 or 4 lawyers. Often this can be done with one lawyer and done much more simply and effectively. Trustees' responsibilities are get in and notify the financial institutions that there's a new trustee, that the new person's in charge, and they're going to have access to the money, access to the treasure chest to use to protect the incompetent person. Their job is to ensure that all the financial needs of the trustor, the incompetent person, and their spouse are met, are taken care of. They're there to follow any specific directives, and they also are empowered to do and engage in nursing home planning to find the best result to either keep the senior in their home or minimize or reduce nursing home expenses. So, trust administration, a number of things. You can see the advantages of doing it privately as opposed to through the public court system. The contrast between the two is rather stark, and I hope we helped illustrate it to you. At its core, we talked about the fiduciary duty. Here's the thing to know, as I talked about the need for professionals, and that is anytime you have a situation where somebody is facing this or has become incapacitated, call us, come see us. We always love sitting down and giving a review, and we will give you our best advice. We'll give it to you straight from the horse's mouth. Here are the things, the directions you need to go. Here's the things that you need to do. And we can also look and see if we need to do some Medi-Cal pre-planning crisis planning to help you avoid nursing home costs and expenses. So that's who we are. All right, mistakes to avoid. I promise you I'd show you a few of these. Let's do a little case study, because case studies are always fun. Here's our old friends, Bill and Mary. If you've been through a few of my seminars before, the faces have changed, but the names have not. So who are Bill and Mary? They have a living trust. And as you remember, it's a contract, and they are in all 3 positions. They're the trustors, the trustees, and the beneficiaries. Bill and Mary have 2 adult children, Susan and John. Both of them live out of state. Susan's our successor trustee and the beneficiary. So Bill and Mary are going on their lives, they're enjoying their retirement, their golden years, they're traveling, they're gardening. They did their plan, but they didn't come back to see us, or they didn't come back to see their existing attorney. They didn't update it. They didn't think about incapacity planning, and they never told their kids about their estate plan or what their roles are. So they figured, well, we did that once, it's all fine. So years later, Mary passes away. And as the trustee of the trust, Bill continues to manage the assets. However, he never reaches out to the law firm. He never thinks about what to do at the death of the first. He doesn't set up subtrusts to protect assets or do anything else that's required of him in the trust. Years later, his health starts to decline. He starts showing early signs of dementia. Physically and mentally, he's not doing so well. He needs help. The kids, because they live out of state, aren't aware about how bad things have got. We see these situations all the time. Or even sometimes when they know how bad things are gotten, they try to talk the parents into doing something and the parents are resistant. Bill fails to add a co-trustee to assist with his affairs, and there he struggles to maintain his situations. We all have busy lives. Well, might have turned out okay, except in our study, turns out that Bill has a very friendly neighbor, Karen. We all know a Karen, right? Karen's our neighbor's daughter, and she wants to help out. She sees poor Bill struggling, and she figures, oh, I can do this. So she starts running errands, doing a little house cleaning, a little medicine management. And it turns out the kids are very grateful. Oh, what a great neighbor. She's so nice. That's so great she can help out. And then she discovers that it's hard for her to, pay for the prescriptions or pay for some of the bills that are invoices that Bill is incurring. So, hey, how about we add our name to the bank account? Let's just put Karen's name on the bank account. And pretty soon, adding the name to the bank account turns into adding the name as a beneficiary on the life insurance and the IRA accounts. Karen's really helping out. During his remaining years, suddenly Bill finds out that his checking and savings accounts have been depleted because Karen has some very expensive habits and she's enjoying herself. The IRA has been depleted or drained. The credit card debt has been added. After he passes away, it's only then that the kids learn what's gone on. They only then learn that they are the trustee, or that Susan was the trustee in our example. The kids are left with only a home, and what they have to do is sell the home to pay off the funeral, pay the debt, and pay the medical bills. An absolute tragedy. Simple thing that could have been avoided if the parents had told the basics. You don't have to say everything, but hey, we've created an estate plan and we just want to let you know, Susan, that you're the first successor fiduciary. You're the first named trustee. You're the medical directive. And by the way, if you want to know, here's where we keep our plan, or here's our attorney. You can contact him if anything comes up. All this could have also been avoided if he had considered adding one of the kids as a co-trustee, or had Susan take over as the trustee to manage Bill's healthcare and decisions. One of the blessings that we have in this modern world with all of our crazy technology, including things like Zoom, where we're talking today, is that you can do a lot of this remotely. You can do it out of state. So you could have Susan, the daughter, take over as the trustee, have her start paying the bills by electronic bill payment, have her make sure that groceries are delivered to the house so that her father Bill gets what he needs. And if she starts seeing money go out of the account to Karen, she can go, what's going on here and why is this going on? So these are all things that could be done. So start to notice cognitive changes. It may be time to make some adjustments to your plan. What would you adjust? One of the things is that you may want to make your power of attorney an immediate appointment. Most durable powers of attorney, if you're not at the stage where you're worried about this, are what they call springing powers of attorney. So in other words, they don't take effect until you get a doctor's declaration saying that Bill is incapacitated. Well, it doesn't have to be that way. A choice you can make is that Bill could sign a power of attorney that says, Susan's in charge right now. She can act right now. So that might be a good adjustment to make if you start noticing cognitive design changes. If an individual has a trust, think about putting our daughter Susan in charge as the trustee right now, as I talked about in a minute. And if the individual doesn't have a trust, this is time to get busy, because it just makes the management of everything so much faster and so much better, preserves tax benefits, preserves control, allows for the protection of assets. Also, if you're staring down the possibility that the care needs are going to be too great, might want to consider spending some time reviewing with us as to whether or not there's any planning we can do to protect you from losing all your assets from long-term care. Okay, what about the next step in the administration process? What happens when somebody passes away? So you remember, when we have a will, where do we go? We go to probate court. That's all we have. When we have a trust, where do we go? We go through trust administration. So probate, as we talked about, is a lawsuit. If it's during life, it's called a conservatorship, and it's needed to manage when somebody's incapacitated. When somebody passes away, it is a death probate or probate administration. Again, a separate and distinct lawsuit. It's potential that you could have two. That's the public system. What is trust administration? It is, again, doing all of these things, staying out of the probate court. And why do you avoid probate? Time and money is the short answer. We talked about the bad things with a conservatorship, but in many ways it's worse. So they're in a death probate. So there are court fees, there are publication fees, bond fees. I have down here that it's time consuming, could be at least 9 months. That's the minimum. And in LA County, more likely it's a year to a year and a half minimum. And that's assuming that the court is open. If you were around during 2020, you know that the court system closed for 4 months and added probably 6 months to every single probate administration that was pending. All it's open to the public, and you can have probates pending in multiple states if you have assets in different jurisdictions. So if you had an asset in, like a little cabin in Maine, or mom left you some farmland in Louisiana, or some oil leases in Texas, you could end up having to do probates in all 3 or 4 of those states, right? Okay, length of administration process in months. Again, a trust is significantly faster. It can usually be done in 5 to 6 months if it's simple. With a probate, it's much longer, and the cost is significantly less. And this gives you, again, another little sort of chart of it. Let's go through the probate process quickly. Again, our key players in a probate administration are going to be at the top of the list, our judge, because we're going to go see a court. Our second person is an executor. That's the person the court puts in charge. Has to be named in a will, but they're the ones that are going to run the probate. They're going to be the dead person. They're going to deal with the dead person's assets once they get appointed by the court. If there's not a will, if there's nobody named, then that same role, the same position, the same fiduciary position is called an administrator. There's going to be the probate attorney. So that's kind of an interesting term here. So first of all, to do this, the vast majority of people are going to need an attorney to file one of these things because they're just very technical. We see people in probate court all the time trying to do it themselves, and the judge is yelling at them and saying, "You're not really equipped to do this," right? Then they'll say, "Well, what do I do next, judge?" And the judge looks at them and says, "I can't give you legal advice. You need help." So there's the probate attorney, the person you hire to help do this. The court itself also has a team and a staff of probate attorneys that review and support the judge. So, but all those people have to be involved. And then finally, there's the beneficiary. So those are our key positions. Again, the fiduciary position, which is our key concern with administration, whether it's probate or trust administration, the fiduciary position is the executor or the administrator. At our first death, typically assets pass directly to the spouse or the next of kin. If the spouse or next of kin lacks capacity, you've got to appoint a guardian or a conservator for their benefit. So this is one thing that a lot of people don't really stop and think about, is how messy these things can actually get. So in a trust, what you typically do is plan for this stuff and say, hey, if somebody's not 25 years old, we're not going to give them the assets outright. But when you're in probate court, especially if you've not written out anything. The probate court's inclination is if you are over 18, boom, they're going to tell the executor to give that kid the money. God help us if you get $1 million of an inheritance when you're 18 or 19 years old. Most often that does not go right. But what if the person who's the beneficiary, so maybe you had left your money to your son, but just before you or in the same car accident, your son died and he left behind a 2-year-old and a 5-year-old. The court can't order money given to a 2-year-old or a 5-year-old. So somebody has to apply for a guardianship for the minor kids. So this probate that you thought was only one lawsuit has now turned into 3 lawsuits. So it's the probate lawsuit, but it's one guardian for each of the 2 kids. And when the money gets distributed to the guardian in the guardianship proceeding, it has to be insured. That's called a bond. There have to be annual accountings to report on the money to make sure the guardian doesn't steal it. And it has to be managed for 18 years until the kid gets to be age of majority. You want to talk about added expenses and nightmares and costs. You haven't even seen anything that you had one of these types of situations occur. And we see them on a fairly regular basis. All right. And then sometimes when you're in probate court, there can be delay or there can be litigation regarding the rightful recipient. So that's the death, the first death and the second death. So the second spouse, again, we have to go through the probate court system. As I indicated, it's not unusual to see a married couple have to file 2 lawsuits, a death probate for each of them, or even 4 lawsuits where they each become incapacitated first, then die. So you have to get power to do that and then pass it along. All right, but the steps that you go through with the probate administration is you send out notice, you publish notice, you contact all the creditors. Every asset has to be appraised and inventoried, so you got to pay for an appraiser to do that through the court system. Any creditor claim has to be paid before any beneficiaries get any money. You change title to assets. That's one of the things we talked about. Remember, a trust, you're changing title ahead of time. So that's what you're doing in probate. And then the court ultimately decides, pursuant to the will or the laws of intestacy, how the estate gets distributed. So that's probate administration. And this is one of the many reasons why it typically takes at least 15 months. And we didn't really go into the cost, but the cost is usually about 4 to 8% of the gross value of the estate. So what that means is, for instance, if you have $1 million house, you're looking at about $50,000 of fees and costs to run through a probate. I'll show you that a little bit later. Okay, the trust administration process. So don't feel bad. I get people that call me up all the time and they look at trust. And some of the old trusts that I see, particularly written by other people, they can be really technical and very confusing if you're not familiar with this world. And that's one of the reasons why come see us, right? We're happy to help you and give you at least an initial roadmap as to how you're doing it. We're doing some of that today, including here and in our trustee book. But that's something that, you wouldn't want to do your own brain surgery. You wouldn't want to do your own, you wouldn't want to build your own car. Most people wouldn't want to do it. It's too technical. Go to people that know what they're doing and know how to do this and avoid missteps. So administration of your trust, your basic duties at your first death are to collect and review all the documents, take custody of assets, notify beneficiaries and creditors, pay any debts or taxes and final expenses, distribute the remaining assets, distribute specific requests, and allocate assets into subtrusts. Now, a lot of technicalities there, but oftentimes if it's a surviving spouse, all the assets are going to the surviving spouse. And the surviving spouse already knows where all the debts are, who they are, and knows what the taxes are. So in many ways, these steps are not that complicated as they appear at first blush. But it depends on the instrument, it depends on the terms of the trust. Sometimes trusts do different things. At the second death, you notice there's a very similar process, but again, you don't have the person that's maybe lived with the spouse. So you have a kid that's coming in, they may not know the assets and the debts and the liabilities as well as the surviving spouse. So what gets done right away? really you want to focus on the funeral. It's one of the reasons why a funeral plan is helpful, including such things as prepaid funerals so that your beneficiaries don't have to come out of pocket for that, or your fiduciaries don't. And you want to get control of bank accounts. In addition to those things, once you take over as the trustee and or as the personal representative, you're going to want to notify Social Security. Social Security has a great way of finding out, and they will take money back from your account if they paid you after the person has passed away. You're going to need to, in many cases, notify the Department of Health Services. You're going to notify the pension companies. You're going to want to gather up the assets, figure out who the creditors are, dealing with expense info, gather accounts online, get access to emails, and look at allocating assets to subtrusts if that is necessary. Your duties are to act for other people's benefits. So essentially with a trust, you need to look at who are the beneficiaries of the trust. So if it's a surviving spouse and the surviving spouse is the trustee, then it's all for them. But oftentimes you'll have one child that is administering the estate for 4 children. So the person that is the trustee has to look out for the interest of everybody, share and share alike. Even if they get very small portions of the estate, they have to protect and preserve the assets. The idea is you need to carry out the intent of the trustor or the person who set up the trust, manage the trust assets prudently. So it's always good to have a financial review to take a look at what's going on. So the fact that your father or your interesting, colorful uncle might have done some really interesting investments doesn't really generally excuse you from doing the same thing, because you are managing assets for other people. But you want to have somebody that can take a look at these things, that can analyze whether you're in good shape. You want to preserve the estate, and you want to do your best to minimize not only income taxes, but all level of taxes. There's potentially real property taxes, there's potentially sales taxes, there's income taxes, and there's potentially estate taxes, depending on your situation. If you're not fluent with how all these things apply to you, again, circumstances where you want to reach out and get some professional help. One of the areas that we see people make the most frequent mistakes is with the recent change in the property tax laws in California under Proposition 19. People make all kinds of horrible messes of these things. So we can help you and guide you through the best way to make sure you preserve the best tax benefit for the beneficiaries. In addition, sometimes trusts have special stipulations or circumstances, for example, for the very young, for the elderly, or the irresponsible or financially inexperienced. So a very common plan well, not common, but certainly it's not unusual, is I'll get somebody that'll come to me and say, hey, I've got an elderly mother who's 85, and if I go suddenly, I want to make sure that there's something there to protect her, but I don't want to give it to her outright because she's about to go in a nursing home, and I just don't want to have all the money go to the nursing home, right? So oftentimes we'll create what are called support subtrusts. So that sets up and sets aside the money for the mother to be able to use to supplement and improve her life and care for her without distributing the assets directly. So if you have one of those situations, you need to know how those trusts are administered and do it in a way that protects the assets and preserves it for the benefit of everybody. You do have a duty to get assets and information to heirs or the beneficiaries in a manner stipulated efficiently without any lawsuits or feuds. You also, if you can avoid them, you also have a duty to notify the income payers, Social Security, pension, corporate pension, VA benefits. You have a duty to create an inventory of assets, including real estate, bank accounts, all these types of things. Generally, what we advise our clients is to go get your hands on the most recent asset statements, gather them all up, keep them safe. And what you might want to do is open up a fresh account and fund all things in one central location, because you're probably going to have to do an accounting in many instances. You want to keep track of creditors and expenses. Is there a mortgage? Is there a line of credit? We've seen estates where people don't understand that there's a mortgage against the property or don't know who the lender is. And all of a sudden the house is in foreclosure and you got to panic and run off and get this thing fixed. So is there a loan? Do they know how to pay it? Do they know how to deal with it? Sometimes banks are cooperative, and sometimes they show no mercy. So you need to know how those work. We've protected dozens of families from the ravages of bank foreclosure, but you need to get in there and get involved. Okay, trust administration steps. After you get through, especially after the death of the first spouse, you're going to want to update some documents, which may include the certificate of trust, the executive summary, healthcare documents. So for instance, if you've named your spouse to be your first medical agent and now she's deceased, you probably want to think about having somebody else be your first agent. Same thing with powers of attorney. And this goes back to my story about Karen. You may want to put somebody in charge immediately. You also need to send notifications to interested parties. So you need to let people know that there's a trust, what the terms are, Social Security, healthcare services, and the pension company. You also may need, depending on what you do, to obtain valuation of assets as of the date of death. That has an impact on taxation. It's not required in every circumstances, and this is one of the areas that we can help and give guidance on how to deal with capital gains, basis adjustment, and the need for proper funding of the trust. So appraisals would include real property. And one of the great benefits you have by holding assets in a trust and maintaining them through death is that you get something here in California called, well, any state that's a community property state, called a double step up in basis, which essentially means you can sell almost any capital asset after death with no capital gains tax. It's an incredible tax saving device. And I see people mess it up all the time. Got to make sure you do it correctly. Save you thousands of dollars. Also, do we have insurance policies? Do we have annuities? What are the distributions options? Do we need to file a claim? Do we need to do all that? Another thing that people don't think about a lot of times is that you have to deal with the taxing authority. So the deceased person had an obligation to pay taxes, most likely. You're going to have to take over and file their final tax returns. Otherwise, if you're managing the assets and you don't deal with the taxes, then you could potentially have personal liability. It's not hard. You just need to do it, and you need to get professional guidance on how to do it. In terms of administration, at first death, you need to look and see if there's any distributions. You also need to see whether there's any specific trust funding requirements. So many trusts have what they call forced splits, or requirement that the trust be split into what are called AB or ABC subtrusts. So do you need to do this? Do you need to think about it? And that's something that of course we can guide you with. At second death distributions, you need to pay attention to specific distributions. Those generally have to be paid within a year of death. Otherwise, they bear interest. You need to be able to make sure you do it correctly in a way that avoids liability for you if you are functioning as the trustee. So before a loved one passes away, I know this is a lot, covered a lot of material today, but here are 4 conversations to think about having now. Bills and money, planning updates and tax planning, online accounts, and the house. So, do your loved ones know about how you manage your finances and your investments? Do they know about your tax situation? Are they going to be able to find your old tax returns? Do they know who your CPA or your accountant is, or how you do your taxes? Do they know about the auto pays that are in place? Do they know what bank accounts or your pensions, so your Social Security? If you've done good planning with a trust, this is part of what we try to encourage and help you get organized. Let's list them all. Let's all list all the big asset accounts. Let's make sure that we've designated them and left cookie crumbs so that your administrator can take over. We sometimes refer to this process as trust funding. I've talked about funding before. This is the organization of your estate so that people can find it when you're not here anymore. So we love reviewing it and making sure that it's done correctly. So you can come in, you can meet with our office, you include any changes and include reviews about estate taxes. And if you need to lodge the will with the court, you can do that, especially on the death of a first spouse. That is law. Many people don't know it and they ignore it, but it's the best place to be. And then social media. Have you written down your passwords? Do they know what accounts? Do they know anything about your accounts? So these are all things to think about. Also, decisions about the house. After you've had the death of the first spouse, is it time to downsize? Is it time to sell? Is it time to move? As I indicated, a lot of people are not aware of the fact that this is one of the best times to think about selling a house, because you can sell a house with virtually no capital gain exposure. So these are all great conversations that we help families with all the time, and we're here to help you and support you through this process. All right, let's give a couple horror stories just to sort of help illustrate some of these principles. So let's meet Rachel and Ray. See how we did that in the clever? Rachel, Ray, they're a little spicy, we might say, right? They like to cook. All right, I'll stop the bad puns. So Rachel and Ray did a living trust. They are all three positions. They have a couple of kids, Sarah and Marco. And they set up their trust so that it would be split into a pair of trusts, a pair of subtrusts after they die. The family trust, which would protect the first to die's basic wishes, and the A trust, which would be survivor's trust, which would have maximum flexibility. So they prepared their plan. They thought everything was fine. But like all of us, they got busy. They refinanced their house. They bought a cabin. They didn't think to put it in the trust. When they refinanced their house, the bank made them take it out of the trust, so they never put it back. They didn't come in for free reviews, and they never updated their plan. They never sat down to review to make sure that their trust was funded. Remember? Okay, forward. Ray ends up having a heart attack and passes away. So Rachel's surviving spouse takes over as trustee. She never bothers to reach out. She never puts the cabin that they bought as joint tenants into the trust, and she never retitles the house, which was also taken out of the trust to deal with the refinancing. So Rachel, of course, is very sad. She misses Ray, and she's lonely, and along comes Carlos. Who's Carlos? Well, Carlos has two adult daughters. He's a very handsome and ambitious young man, or, about her age, I guess. Moves into her house, and they start paying bills and buying groceries. Just be easier to add you to the accounts. Pretty soon he gets added on as beneficiary of the life insurance. And then why don't we put him on as a joint tenant to the house and the cabin? And Rachel never comes back and forgets to update her estate plan. She figures, I got a trust. My kids are protected. It'll all be fine. Except what did she do? She pulled all of the treasure out of the treasure chest, and through a couple of technical reasons that she didn't really think about, none of them are funded and properly protected. So Rachel passes away. Sarah takes over. She calls the office. She plans the future, or the furniture, but then she discovers that none of these assets have been properly funded. So essentially, there's no treasure in the treasure chest. She discovers that Carlos receives the IRA and the life insurance. So we now have a dispute as to whether if she put Carlos on title to the property, whether it goes to Carlos or whether it's a probate asset. And then when Carlos passes away, guess who receives the assets of the estate? Turns out it is not the children of Rachel and Ray, but instead Carlos's children. And it's Christmas in July. They are very happy. They have the home, they have the cabin, they have the life insurance, they have the IRA account, and the other kids receive the personal belongings. So what do we learn here? That if they had sat down and reviewed the plan on a regular basis, they would have caught the issues at the first death, and they would have put in plans of protection to protect against remarriage. We're titling and refinancing of the home. We would have put it back in the trust. We put the cabin in the trust. We would have not have encouraged adding Carlos to all the checking accounts, and we would have protected the family. So this is one that we see on a regular basis. It's rather sad, but it's one of the reasons why it's important to come back and check with us. All right, client mistake number 2 to avoid. Another case study, second death. So let's meet David and Shirley. They have a living trust. Like a lot of us, they are the trustors, trustees, and beneficiaries. Here are their kids, Jamal and Leslie. Jamal is the named successor trustee. David passes away first. Shirley passes away 2 years later. Jamal steps in and takes over as successor trustee, but doesn't bother to call our office, doesn't set up a common pot trust, which is what the trusts are called for, and doesn't distribute assets for Leslie's needs. In the meantime, he changes the title on financial accounts. He cashes out the IRA and the life insurance because he's got to pay bills, he's got to pay for the funeral. He also gets presented with a sure deal. Maybe he wants to invest in some crypto because that's really wow, or maybe a sure deal stock. He moves into the family home and distributes all the assets before the bills are paid. So what Jamal learns the hard way is that he has breached his essential fiduciary duty because he's washed out for his interest by investing in the stocks. He created unnecessary tax consequences. He ended up paying unexpected taxes and medical bills. He also discovers that he has personal liability because he didn't address these things first. He doesn't get around to filing an income tax return. His accounting is a disaster. It's not clear that they receive equal shares. And he's, in short, completely mismanaged the estate. So estate plans are essentially abandoned and not updated. Trusts are not funded with assets, and the future trustees are not informed, they're not prepared, and they're indifferent until there is a crisis. So the way that we often see this type of particular mistake is that we will get a call 2 or 3 years after somebody has passed away. It's almost never one of our estate planning clients, it's another one. It's somebody did the trust with somebody else, and they'll say, hey, my brother's the trustee and he won't tell me what's going on. He hasn't given me anything. He won't explain it. I try to get him to explain it. He won't. We push on somebody like a Jamal and say, what's gone on? Explain what you've done. And Jamal is a disaster because he can't explain how he's used the money or spent it. So these create incredible lawsuits and a lot of pain and heartache. So assets may end up going through probate because they weren't properly funded or because he made bad choices. The wrong people ended up inheriting, chaos erupts, and there's financial losses because we haven't thought about any of these things. Confusion, stress, disappointment, resentment, family disputes, and added delay. So we say a lot of times you don't know what can hurt you. You don't know what can hurt you. So what appears to be sort of an innocent decision or a simple change or just I'll get around to it ends up being an absolute disaster. So don't hesitate to seek professional experience. See an accountant, see an estate planning attorney, see a financial advisor, see a real estate agent, see an appraiser. Do this correctly. All of these topics are your estate and your wealth. All of them are more sophisticated than many of us give it credit for, and they can create all kinds of problems. All right, quiz time. Are you ready? Let's see how well you've absorbed this. Don't worry, I will not be publishing quiz results. So first up, if I'm the successor trustee of the trust, can I change the terms of the trust? What do you think? False. You cannot. When you are the successor trustee, your power is limited, and often you're the successor trustee because the settlor has died and the trust becomes irrevocable. So if you ever hear somebody like a successor trustee administering mom's estate and she says to you, oh, you better be nice to me or I'm not going to give you anything or I'm going to change your inheritance, he or she doesn't have the power to do that. Only the person that set the trust up has the power to do it. Next up. I did my trust, but one of my children changed their legal name. They got married. Do I have to run in and see you, Scott? Do I need to update your estate plan? What do you think? True? False? False. Isn't that good news? As long as we knew who this person was, as long as they were Susie Jones or whatever their name was at one point in time, the trustee has the power and the ability to be able to figure out who it is. And a name change doesn't require that you do that. So, don't have to make changes for those reasons. Next question. I appointed my 2 children to serve together as successor trustees. True or false? If they are successor trustees, must they agree on everything? I.e., must they work unanimously? Extra credit, true or false? they must live in the same state in order to be co-trustees. What do you think? Do they have to act unanimously? True. They must act unanimously. That's one of the problems with co-trustees. Now, they can do some delegation if they're cooperative, but it's one of the reasons why we strongly advise against naming children or naming people other than your spouse to be a co-trustee with you. Because if you can't get them to cooperate and there's not an easy way to resolve it, you end up in the court system. So generally, we like to put one person in charge, recognizing the fact that that person has that awesome fiduciary duty. They have responsibilities. They have to act fair and properly. That's how we deal with it. How about the extra credit question? Must they live in the same state to be co-trustees? And the answer to that is false. You do not have to be a California resident to be a trustee of a California trust. Now, if you're an international resident, that creates some problems. But in this day and age, we can do all kinds of things with trustees working from around the country, and we often do. Next question, funding. My favorite word, right? Funding. If I fund my checking account into my living trust, I fund my checking account into my living trust simply by listing it on Schedule A, true or false. So when we create a trust, we will generally list your assets, right? And if you didn't do your trust with us, do you have a schedule of assets? Is that enough? Does that fund the trust? And then true or false, my bank told me I need to use their power of attorney form to get access to the account, and I must use the form as they say. What do you think? First question, false. Listing an asset on a schedule does not fund it. That is not enough. It is certainly an expression that you meant it to be a trust asset, but you actually have to go to the bank and you have to change title to the asset. I have had and have pending lawsuits over this very issue, where beneficiaries have hard feelings about how assets were eventually funded. A scheduled assets is not by itself sufficient to fund it. How about the bank's power of attorney? It just depends on the bank, but generally, if you have it in the trust, what you're going to want to do is have it as a trust asset, and then the trustee takes over. All right, next, power of attorney. I want to keep my incapacitated spouse's ex-spouse from visiting them in the hospital because it is upsetting to my spouse and the family. True or false, the healthcare power of attorney will be sufficient to control access. So does the healthcare agent have the power to be able to control who visits you when you are in the hospital? What do you think? Well, the answer is true. That's one of the great things, is you are outsourcing and you are appointing the person that is going to make these decisions for you. So you really want to, when you make this selection, find the person that knows your heart, right? That really understands who you are and what's important to you. Next question. My mom has dementia. She started to forget to pay her bills, and I am listed as the successor trustee. True or false, I can just start writing checks on her account to pay her bills. What do you think? True, false? You just take over, write checks? Answer is false. What you have to do is you have to actually take over as trustee. So your mom has to consent. You have to notify the bank, and then the assets are held by you at that point as the successor trustee. That's when you get the power. True or false, using a power of attorney. When I sign my mom's name as attorney agent, I simply sign my name, Susan Smith. So if you've ever used a power of attorney, is that how you do it? You just sign your own name? What do you think? True, false? Answer is false. The way that you sign using a power of attorney is to disclose your capacity. So your mother's name, Mary Jones, by Susan Smith, her attorney, in fact. You're disclosing the agency relationship. That's the way it works. Next, oops, I forgot to pay that. As trustee, I distributed all the assets to the beneficiary, and I just found out that the decedent owed taxes. And there's no money in the living trust. In that case, will the IRS waive the tax liability because there's no money left in the trust? What do you think? Yeah, that's a big false. IRS rarely waives liability ever, but that's one of the big risks as a trustee is you need to make sure that you understand what the tax liabilities are, because tax liabilities get paid before beneficiaries get everything. So where we often see this play out is mom dies and the other kids are knocking on the door. Where's my money? I want my money now. Slow down. Trust administration takes a little time. And if there are complicated tax problems, it might take longer. But that's one of the things that a fiduciary has to do is make sure that the taxes are properly managed. All right. Next, I am concerned my family will fight over my terms of my trust when I die. True or false? I can discourage a frivolous challenge to my living trust if I'm concerned that my family will fight over it after I die. I think, is there anything that can be done? Answer is true. It can. This is something that we're very good at. We can build clauses that really encourage people to not go into a war, to not fight, that really gives them a good chance and treats them fairly. So we can discuss all those things with you and really help you minimize fights. All right, post-death, my dad just died and I'm not sure what I should do first. True or false? My estate planning attorney should always be the one of my first people that I contact after a death occurs. What do you think? Should you call up an attorney to figure out how to do a trust, how to administer a trust? Well, I might be a little biased, but I think the answer is true. These are sophisticated, complicated documents. When you're talking about asset accounts, financial accounts, houses, house transfers, mortgages, these are some of the most complicated financial things that most people deal with. And you don't want to just sort of blindly jump in without realizing and being guided on the best way to minimize taxes, the best way to minimize problems, the best way to avoid being sued for mismanaging all of these things, right? So reach out, give an attorney a call. So who will help you when you or your successors, when something happens? This is how we help at Incapacity. With a client in declining health or diminished capacity, come in and see us. We can implement or trigger the living trust. We can implement the power of attorney. How do we help at death? Always call us. The first meeting is free. That includes preparation of certain documents that the trustee will need. We will explain legal requirements and steps to settle an estate. If legal services are required, we usually do them on a flat fee basis. By the way, today's topic is called Trustee School or Trust Administration. But if it isn't really obvious, we handle a whole ton of probate administration. We're as good at probate administration as we are at trust administration. We just prefer that you not do probate administration, but we do it very well. So if you discover that your uncle died without an estate plan or somebody you know is in probate, call us about that too. We help with all of these things. So our fees. So this gives you a basic idea. In probate court on the right-hand side, fees are determined by statute and there are minimum fees. And so you can see that if your estate is worth about $1 million, you're going to pay about $47,000, almost $50,000 in fees and costs as a minimum fee. In contrast, for a $1 million estate, for most cases, we do it at a rate of about $8,500, significantly less. And for that, we will get you through all these challenges and problems we talked about, including guiding you on the best way to manage these tax efficiently, making sure you're protected from being sued for mismanaging assets, that you can account correctly, all of these types of things. So your action plan, have a conversation with your family now. Use our family conversation checklist. Review your estate plan with your family or your successor trustee. Organize your personal information and affairs. When you're a client of ours, we give you robust tools to do that. Not only do we schedule your assets, we have a tab of the binder where you can go through and put your professionals and all the people that are there to help you and that can take over. You can also review all your beneficiary designations. So create an action plan now. If you haven't reviewed the funding or the beneficiary funding of your trust or the beneficiary designations in your plan, make sure you do that right away. That's the most important thing. Take a look at your trust and your powers of attorney. Make sure they include digital powers for all this new social media and online banking stuff. Make sure they're current. My own family, when my father was sick, we pulled up his estate plan and discovered that everybody was either dead or somebody that he hadn't seen in decades, right? So who are your agents? Who are your trustees? Have you reviewed this? Come in for periodic reviews from time to time. We can review your family and your life and review your goals. How often should you review your estate plan? Our feeling is that you should do it every 3 to 5 years. You can review the checkout in the checklist in the handout. You should do this more often if you have life changes. So if you have a divorce or older children or there's changes in the law, we often send out notices. You get the idea. So your next step is you can schedule a free review meeting if you want. If you don't want to do that, you can always call and we can answer questions about your current situation. What about a successor trustees action plan? You want to make sure you inform yourself. You want to know what documents exist, where to find them, and make sure you understand what tools each tool does and when to use them. Next question, of course, is especially if you're a child watching this and say, do I need an estate plan? Well, here's the basics. If you own real estate in California or anywhere in the country, if you have assets of more than $180,000, if you have minor children, if you want to control where and how your assets go, and you're over the age of 18, there's a good chance that you need an estate plan. So if you've answered yes to any of these questions, the answer is book a personal consultation. Come in and see us. We can schedule something and review this with you. So for new clients, by sitting through our seminar today, hopefully enjoying it, we are going to offer you this opportunity. You can schedule an appointment, a consultation to see if you want to do an estate plan. If you're serious about doing something about an estate plan, we only have a few conditions. One is we say here within 2 weeks, but because of the holiday, basically by the end of the year, get something scheduled. If you're married, unless you're about to divorce or have separate property and don't want your other spouse involved, I need both spouses there. Generally, I charge at about $700 an hour, but I will give you, I believe the importance of this, that I will give you an hour, at least of my time, for you to come in and see me. We consider our clients and their families as part of our law firm family. We're here to support you and help you get through this. So feel free, if you found this helpful, to register with our emails, check in with our educational events. We do both educational events on trust and estates, but also on financial planning to make sure you're empowered in that area. So let's talk about fees. If your question is, I need to do an estate plan, what do you charge, Scott? How much does it cost? Well, I've detailed all the ways it can go wrong and all the things that could go bad. And as we like to say, there's a few places in life where you want to avoid bargains. Those include surgery and parachutes and estate planning. And why? Because you're not going to know there's a problem until it's too late. So our fee for doing planning for everything that protects your plan, including funding, we do it on a fixed fee of $5,495. And if we can help you, we would love to be able to do so. So think about it, and you can schedule your consultation. If you are handy with a QR code, you can scan that and pop right onto our site, and you'll get access to my calendar and can schedule an appointment that way. If you're not a QR code person, do not panic and do not worry. We do this the old-fashioned way as well. We would love to get a call from you. We would love to get an email from you. You can write us, you can call us, and we will find a time to see you. Now, in this day and age of COVID, please realize that we do this both in person and through Zoom video conference, so we can keep our distance. We do a lot of our consultations by Zoom, and we love seeing our clients by any way we can. So what can you expect if you come see us? If you are coming to see us, basically, we will review your situation. I'll get to know you. I'll make sure I'll inquire what's most important to you, and then I will turn everything over to you to answer any questions or concerns that you have about why you came and what's important to you. At the end, I will ask you to make a decision. If you're not a client of ours, do you want to work with us? Do you not? If you're, of course, there just for a review, if you're an existing client, we'll give you a course of action and a plan, and we'll decide on any steps that need to be done. We also love and are happy to do a portfolio review and diagnosis. We are in the job of preserving and growing generational wealth. And if you want us to look and see if we see any obvious red flags or problems with your portfolio, or whether it matches your wishes and desires, we can do that. So share what you've learned with others, friends, families, business associates. If you have an interest in coming to speak, have us speak at one of your events, we're happy to do so. Just reach out. We love educating people, and we value your opinion. So feel free to share feedback online. If you didn't like any of my jokes, you can tell the world that. If you found any of this helpful, you can tell the world that. Whatever's in your heart. We love dialoguing, communicating with the people. So next, I will turn to our chat. I see that we have a couple of questions. I went a little long today, so I'm going to try to be fast. But let's resolve. So,